Okay, ready? 1, 2, 3. Hold on now. Wait a minute, fellas. Wait a minute. I think it goes something like this. Whoa. 1, 2, 3, 4, 5, 6. Can somebody take these burdens off of me? Off of me. Can somebody take these burdens off of me? Off of me. Cause every time I turn around, there's something trying to keep me down. Can somebody take these burdens off of me? Off of me. Whoa, can somebody take these burdens off of me? Off of me. Can somebody take these burdens off of me? Off of me. When I look up, don't you know, burdens knocking at my door. So won't you come and take these burdens off of me? Off of me. Oh, come and take these burdens off of me. Off of me. Somebody come and take these burdens off of me. Off of me. Soon as I get up off the ground, my burdens knock me right back down. Can somebody take these burdens off of me? Off of me. Somebody take these burdens off of me, off of me. Somebody take these burdens off of me, off of me. Somebody take these burdens off of me, off of me. Well, off of me, off of me. Oh, off of me, off of me. Well, off of me, off of me. Get them off of me, off of me. Come and break the chain. Come and break the chain. Get it off of me. Get it off of me. I need somebody. I need somebody. I need somebody. I need somebody to get this burden. To get this burden. Can somebody take these burdens off of me?
Just in my rehearsal room. Hold on, hold on, hold on, hold on, hold on, hold on, hold on. Everybody hold on. Hold on, hold on, hold on, hold on. Robert is coming home. He's coming home. Hold on, everybody hold on. Robert is coming again. He's coming home. Hold on, everybody hold on. No matter what they say, no matter what they do, no matter how it seems, God's got the final say. It doesn't matter how long it may seem, the end is what matters. But God's got the final say. So hold on, everybody, hold on, hold on, hold on, hold on, oh, hold on, hold on, forever, hold on. The enemies may hate, they can tell all lies. No matter how long, the truth will prevail. They can rise up against all the fans that stand up for him. The end will justify, for God has the final say. Oh, no, 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 yo. Hold on. Hold on, hold on, hold on. Robert is coming home. He's coming back, so hold on. All fans, hold on, hold on, hold on, hold on, hold on. Hold on, hold on, hold on, hold on. Help is on its way. Heaven is down here. Hold on, all fans, hold on. God is here, taking it over. Hold on, everybody, hold on, hold on, hold on, hold on.
Hey everybody, how you guys doing? I wasn't gonna come on because, as you guys know, I am consecrating myself for the next 3 days. So I was staying off of all social media platform. But I did make a promise that if the judge would submit her decision, I was going to come on. But then motions are being submitted. So I've been getting bombarded with emails, texts, and are you going live? But I had to do my prayer time, and I've been focusing on fasting and praying. So that's where I'm at. But I did decide to come on to give you guys some information. But prior to me doing that, I need to share something with you first. And this is a message, is what I've been standing on what God has told me in regarding to fasting and praying. But just listen to this. It's not going to be long. I'm just going to play about 3-4 minutes of this, and then I'll go ahead and read the motion. Okay.
Prayer is the most important key of the kingdom. Prayer is the most important key of the kingdom. There is no key to the kingdom of heaven, but there are keys of the kingdom of heaven. And the most important one, in my humble estimation, is prayer. That is verified by Jesus Christ, the King himself. He saw prayer as more important than anything else. We will see that during this next few days as we show you in Scripture why prayer is so important. We'll also talk about fasting as being the most powerful tool in prayer. Prayer is the most important key, but fasting is the most powerful tool of prayer. Praying is wonderful, and praying effectively is wonderful. But when you mix prayer with fasting, it's awesome. And we need to see why those two go together and to rekindle our love for prayer. Let me begin to talk, first of all, about the priority of prayer, why prayer is so important. You will notice that all religions pray, all of them. Buddhists, Hindus, Muslims, Confucius, Scientologists,
Unitarians, everybody prays. So prayer is a part of a religious mechanism for mankind. Now let me explain something as to why all religions pray. All religions pray because the desire to contact and commune with the supernatural is inherent in the heart of all human spirits. So don't be confused that because a person prays, it means that their prayer is being answered to the right God. The desire and the hunger to pray or to commune with a supernatural being is proof that the human spirit is not from this place. Many times we don't know who we're praying to or don't know why people want to pray. If you study the uncivilized, so-called uncivilized tribes that they keep discovering, and you go sometime into the history and you read how they find these tribes that were way in the jungle somewhere, no contact with modern humans, and yet that tribe has a ritual of prayer. Maybe they pray to the moon, or they pray to the mountain, or they pray to an animal, or they pray to a tree. They pray to something. There's this human desire to pray. So because we say that everybody prays, doesn't mean everybody is praying correctly and praying to the right or to the true God. There is a scripture I want you to turn to that you probably don't read much, Ecclesiastes chapter 3. And there is a simple verse found in Ecclesiastes about why 7 billion people on earth have a desire to contact the supernatural. Even the atheists would get involved in Ouija boards. Even the agnostic would want to practice black magic or white magic. Even those who claim that there is no God but still want to, however, even follow what they call horoscopes. In other words, everybody, no matter what they say, don't let them fool you. Deep in their hearts, they want help from somewhere that is above the natural. Whether it's a star, on their birthday, or whether it's some unknown spirit or spirits, even ancestral spirits. Humans are always wanting to contact the supernatural. Here's why. Get your pen and underline this. I'm going to show you why. Ecclesiastes chapter 3. It says, to everything there's a season and a time to every purpose under heaven. And it lists all the different seasons of life. And then it says, verse 10, I have seen the God-given tasks with which the sons of men are to be occupied. He has made everything what? Beautiful in its time. Also, underline this, he has put eternity in the hearts of every man, except that no one can find out the work that God does from beginning to end. He has put eternity in the hearts of every human. That statement means that every human being knows somewhere that he came from somewhere that is not here. And he has a hunger to reach out to the eternity. Some use idols. Some use ancestral spirits. Some use voodoo. Some use white magic. Some use seances. Some use Ouija boards. Some use booga booga. Everyone wants to reach out. And so when the Buddhist sits down and burns an incense, or a Hindu puts food out in the night and burn candles and build little houses to feed the spirits, and when the Muslim reaches toward the east and bows to Mecca and prays 7 times a day. And when the Jew goes to the Wailing Wall and bows and cries out, rocking in power and possession, these are all human spirits feeling the need for eternity. So prayer is common because prayer is man reaching out to somewhere else for help. Write this down. Number 2, prayer is not an option for us. In the kingdom of God, we are commanded to pray. You cannot say that you follow Jesus Christ as your king and don't pray. It's impossible. He commands us to pray. Thirdly, prayer is the most common experience of those who say they are believers. Normally, when you give your life over to your so-called God, whether it's Buddhism, Hinduism, Shintoism, Scientology, Christianity, whatever, they always tell you you got to pray to this God. And so we have people burning incense, people going to a temple to the Buddha, people going to the Hindu gods, 6 million of them. And everybody's going through their rituals. They're getting their royal baths, bathing in the royal river, all this stuff we go through because everyone is wanting to experience the supernatural. God commands us who believe in Jesus Christ to pray. And number 4, prayer is the most talked about but least practiced activity of religious Christians. Every so-called Christian talks about prayer, and hardly none of them do it. Prayer for most people is like buying a cookbook. You got a cookbook in your home, but never made a single meal from the recipes. We know that we should pray, but we don't do it. We don't practice it. And the question is, why don't we practice prayer? Why isn't prayer an excitement for us? Why is prayer so difficult? Here's another question. Why are prayer meetings the smallest meeting in every church? You go to any church in this country or any other country, and you will find on Sunday mornings, or if you are a Shabbat worshiper, on Saturday mornings, the place are filled with people. But then Monday night prayer meeting, 3 old ladies who ain't got nothing else to do. And they are praying. But what happened to all the folks who were there Sunday morning? Watching TV, playing games, going out to social events. Question, why are prayer meetings the smallest meeting in every church? How about this? Another question. What did Jesus say the house that we meet in is supposed to be called? Now, we normally say a house of worship. That's what we call it. He didn't call it that. So we run to this building, whatever your building is, we run to this building to worship. Christ says, my house shall not be called the house of worship. It's to do something more important. Oh dear. You're looking at me funny. What did he say his house should be called? House of prayer. In his mind, it's the most important activity of humans, especially when they come before God. So if prayer is the most important activity of God's priority on the list, then why isn't the prayer meeting the largest meeting in the church? Answer, because people don't get results. And the human spirit is a very interesting spirit. We don't like to do things that don't benefit us. We love to avoid resistance. When things don't work, We avoid them. So we refuse to keep going to a prayer meeting if we feel that this is not working. Do you remember when you first got born again? You went to prayer meeting 7 days a week. They couldn't keep you out of the church. And now, no comment. But why? Because of lack of results. I was the same way. I was brought up in a very religious environment. And they had prayer meetings. I aligned myself with the Brethren Church. And then we went to the Baptist Church. Then I went to the Pentecostal Church. I went to the Assemblies of God for a while. And then I went crazy. I went to the kingdom. And in all those experiences, the prayer meeting was always the smallest meeting. Because people didn't get results. Prayer for most people is like going to a vending machine to buy a soda. And you put your first 2 quarters in, and you hit it, nothing comes out. You put 2 more quarters in it, you hit it, nothing comes out. You put another 2 quarters, and nothing comes out. And after a while, what do? First, you kick the machine. Don't forget that. I ain't going back to no prayer meeting. Bam! That don't work. And then you start talking bad to the machine. You dumb machine, you stupid machine. And then you walk away and you avoid the machine. That's what prayer has become to most people. We keep praying and nothing happens. So we decide to stay away. I hope that after this 21 days, God will give you so many answers that you would want to love prayer every single day. Matter of fact, you would pray like Jesus said, pray without ceasing.
Amen. I just needed to share that with you guys. I needed to share that with you, and that's what I'm doing. Consecrating myself, praying, and going before the Lord. So that's one of the reasons why I decided to be off social media for the next 3 days. But because folks kept texting me and requesting that I go live, I decided to go ahead and read this motion. Here's the key. This motion came out while we're in consecration. We started the fasting and praying at 12 a.m. today. And we are praying in expectation. And we know God is moving. This is no surprise for us believers. So it's just going through the motions right now. I'll go ahead and read this to you guys, but I'm not impressed because I already know what God already said. So I'm going to go ahead and read this. And I hope you guys will stop bothering me while I'm going through my consecration. Okay? All right. United States District Court, Northern District of Illinois, Eastern Division. United States of America plaintiff versus Robert Sylvester Kelly, also known as R. Kelly, Daryl McDavid, and Milton Brown, also known as June Brown, defendant. Case number 19CR567, Honorable Harry D. Ledenweber. Motions to dismiss counts 1 through 4 and 6 through 13 of superseding indictment as time barred. Now comes the defendant, Robert S. Kelly, by and through his counsel, Jennifer Bonjean, and move this court to dismiss counts 1 through 4 and 6 through 13 of the superseding indictment as time barred. Introduction. In its recently discovered enthusiasm to prosecute Mr. Kelly, the government reaches back a quarter century to bring charges of sexual abuse and receiving child pornography that have been time barred. Count 1 through 4 of the indictment alleges child exploitation of minor 1 that occurred between 1998 and 1999. Pursuant of the operative version of US 18 USC 328, the government had until September 2009 in which to charge defendant with 2251A. Offenses arises from this conduct. Because the statute of limitation ran more than a decade ago, this court should dismiss counts 1 through 4 of the indictment. Similarly, counts 6 through 8 of the indictment allege conduct that occurred between 2001 and 2007. Because these offenses, which claim the defendant received child pornography, are subject to a 5-year statute of limitation, they are time barred. Even assuming the applicable of 18 USC 3283 to count 7 rather than the general 5-year statute of limitation set forth in 18 USC 3283A, the statute of limitation for this count expired in 2009 when minor 1 turned 25 years old. Counts 9 through 13 suffer from same timeliness problem. The Mann Act violation charges in count 9 through 13 allege count that occurred between 1996 and 2002. Again, pursuant to the operative version of 18 USC 3283, the statute of limitation for these count ran upon the minor's 25th birthday, which occurred no later than 2009. Accordingly, this court must dismiss all count of the indictment as time barred, with the exception of count 5, which was already subject of a motion to dismiss of statute of limitation grounds. Allegation. On February 13, 2020, the government filed a superseding indictment charging defendant with 4 counts of child exploitation of a child, conduct that allegedly occurred in 1998 or 1999, docket number 93. Specifically, the indictment accuses defendant of engaging in sexually explicit conduct with minor 1 for the purpose of producing 4 separate videos between 1998 and 1999. Counts 1 through 4. Count 6 through 8 of the indictment accuse defendant of conspiring to and then receiving those same videos or copy thereof in 2001 and 2007 in violation of 2252A after the video were allegedly stolen from defendant by individual D. The superseding indictment further alleges that defendant committed numerous Mann Act violations pursuant of 18 USC 2422B. Specifically, the government contends the following. Between 1997 and September 2001, defendant did knowingly persuade, induce, entice, and coerce minor one to engage in sexual activity that constitute aggravated criminal sexual abuse under Illinois law, count 9. In the summer of 1996, defendant did knowingly persuaded, induce, entice, and coerce minor 3 to engage in sexual activity that constituted aggravated criminal sexual abuse under Illinois law, count 10. Between 1999 and 2000, defendant did knowingly persuaded, induce, entice, and coerce minor 4 to engage in sexual activity that constituted aggravated criminal sexual abuse under Illinois law, count 11. Between 1997 and 2001, defendant did knowingly persuaded, induce, entice, and coerce minor 5 to engage in sexual activity that constituted aggravated criminal sexual abuse under Illinois law, count 12. Between 1997 and 2000, defendant did knowingly persuade, induce, entice, and coerce minor 6 to engage in sexual activity that constituted aggravated criminal sexual abuse under Illinois law, count 13. Argument. With the exception of count 5, which was already the subject of a motion to dismiss, all counts of the indictment must be dismissed as time barred. Federal Rule of Criminal Procedures 12B3B allows a party to raise a pretrial motion, a defect in the indictment or information, including failure to state an offense, Rule 12B1. More generally, allows a party to raise by pretrial motion any defense, objection, or request that the court can determine without a trial on the merits, including an argument based on the statute of limitation. Federal Rule Criminal Procedure 12B1 and B12 Advisory Committee notes, pursuant to Federal Rule of Criminal Procedure 7C1, an indictment or information may be a plain, concise, and definite written statement of essential fact constituting the offense charged. The indictment need not allege in detail the factual proof that will be relied on to support the charges. United States versus Smith 230, and that's a whole court case. Cited here, a case cited. An indictment is legally sufficient of it. 1. States all elements of the crime charge. 2. Adequately inform the defendant of the nature of the charges so that he may prepare a defense. And 3. Alleges the defendant to plead the judgment as bar to any future prosecution. United States versus White 610, and it's the whole case, or in that one. A court assumes all facts in the indictment are true and must view all facts in light most favorable to the government. United States versus Ushar, that's a case right there. A. The limitation period for all counts alleging conduct that preceded 2003 are time barred. Because the statute of limitation for counts 1 through 4, 7, and 9 through 13 identify expired no later than 2009. They must be dismissed as time barred. Federal law imposes a 5-year limitation period for most non-capital offense. 18 USC 3282A. However, Congress provided a longer limitation period for offenses involving the sexual or physical abuse or kidnapping of a minor. US 18 USC 3283. At the time, defendant allegedly committed the offense set out in counts 1 through 4, 7 and 9 through 13. 3283 provided as following. No statute of limitation that would otherwise preclude prosecution for an offense involving the sexual or physical abuse of a child under the age of 18 shall preclude such prosecution before the child reaches the age of 25. Thus, at the time of the charge conduct, the statute of limitation for offenses involving sexual abuse were extended until victim/minor reaches 25. In 2003, Congress amended the statute, extending the statute of limitation through life of a minor. 18 USC 2383. Congress did not express an intent for 2003. Amendment to apply retroactively, consistent with the well-established presumptions against proactive legislation. The 2003 amendment is inapplicable to the charge's conduct as it is any subsequent amendment. See United States versus DILA. That's a case that she just referenced. In effect to the time of the defendant's offense rather than the amended version, in effect to the time of the indictment. Consistent with the established principle that criminal limitation status are to be liberally interpreted in favor to repose. This court should reject any argument in favor of retroactive application of the 2003 or 2006 version of 3283. Torsi versus United States. That's another case than the numbers. As a general rule, retroactivity is not favorable in the law. Then she gave another case law, and then the Supreme Court has explained that with a very aversion to retroactive rule making. And then she brings up a little piece in there. I'm going to read that. It is deeply rooted in our judicial prudence, and in the embody of legal doctrine, centuries older than our republic. Elementary consideration of fairness dictate that individuals should have an opportunity to know what the law is and to confirm their conduct accordingly. Settled expectations should not be lightly disrupt. For that reason, the principle that the legal effect of conduct should ordinarily be assessed under the law that exists when the conduct took place has timeless and universal human appeal. Then she gives the case law on this one. And she says the Court of Landgraf set forth a framework for determining whether a statute applies retrospectively or pre-enactment conduct. The court articulated a two-step analysis to evaluate the purpose of retroactive application of a status. of a statute, sorry. And then she gives another excerpt from from that case. The court's first task is to determine whether Congress has expressly prescribed the statute's proper reach. If Congress has done so, of course, there is no need to resort to judicial default rules. When, however, the statute contains no such express command, the court must determine whether the new statute would have retroactive effect, i.e., whether it would impair rights of party posing when he acted, increase in parties' liability for the past conduct, or impose new duties with respect to transaction already completed. If the statute would operate retroactively, our traditional presumption teaches that it does not govern absent clear congressional intent favoring such a result. Then you give the where it's gotten from. And it says, under the Landcraft, if Congress has expressly prescribe the statute applied retroactively or will not apply retroactively, the inquiry ends. If the statute is silent on the issue, court proceeds to the second step of the Landcraft analysis and determine whether the new statute would operate retroactively. Here, the 2003 amendment of 3283 contains no language expressly prescribing retroactive application of amendment. The statute also does not expressly provide that it may only apply prospectively. However, Congress considered and rejected language that expressly prescribed retroactive effect. Indeed, the legislative history leaves no doubt as to congressional intent. The House version of the bill provided for the complete elimination of a statute limitation and included an express retroactive provision. Child Abduction Prevention Act H.R. 1104, 108th Congress 202, 2003. The Senate version contains no retroactivity provision. Project Act S 151, 108 Congress. The House and the Senate conferred to resolve difference between the bills. The retroactivity provision was omitted. Senator Leah, one of the original bill co-sponsor and a former chair of the Senate Judicial Committee, stated on the Senate floor the omission was intentional. I am pleased that the conference agreed to drop language from the original House passed bill that would have extended the limitation period retroactively. Senator Leah Amber legislation, a bunch of numbers, okay. The legislative history of the bill expressed Congress' intent that the amendment apply prospectively, and there's a bunch of numbers here. And then it's give us, okay, I'm going to pass all of these little numbers they have here. Our inquiry is not limited to the statute text, but may include an examination of standard inside the statutory construction, such as the statute, truck, and legislative history. In sum, Congress affirmatively rejected the proposed retroactive application provision, indicating its intent that the statute applies prospectively. Even if this court concludes that the Congress intend to express retroactive application of 2003 amendment fails to pass the second prolong of the Lagrave test. The United States Supreme Court held in Stronger versus California 539, bunch of numbers, that retroactive application of extending statute of limitation is revived. Time barred claim violate the ex post factor clause. The government is sure to argue that in 2003 amendment did not revive time-barred claim in this case, but rather extended the limitation period to prosecuting those offenses before the limitation period expired. Admittedly, some court would agree that extending a limitation period before a prosecution is time barred does not run afoul of the ex post factor cause. Then a bunch of numbers. However, in analysis that the retroactivity of a criminal statute of limitation under second step must recognize the principle that unlike civil statute of limitation, criminal limitation has to be liberally interpreted in favor or repose. They give a case number there. And then she goes, observing that if Landcraft and Torsi are read in conjunction, courts must interpret the statute of limitation in a manner favoring repose for defendant. As the First Circuit has acknowledged, Torsi potential altered the second step of Landcraft approach in criminal cases. United States versus Miller, and there's a bunch of case numbers there. Evaluating 2003 amendment in adjunctating, whatever the word is, ineffective assistant of counsel claim. In other words, when Congress has sounded an uncertain trumpet, a court ought to refrain from applying enlarged criminal statute of limitation retrospectively, as discussed in Supra. Congress sounded an uncertain trumpet regarding the retroactivity of the 2003 amendment when it affirmatively removed a retroactivity provision from the bill. In light of Tursi, this court should reject a retroactive application of the 2003 amendment, even if it's not the equivalent of the ex post factor violation because it runs afoul of familiar consideration of fair notice, reasonable reliance, and settled expectation. Put differently, defendant urges this court to read the second step of Landcraft as providing a broader protection for criminal defense than the ex post facto cause. Statute of limitation applicable to criminal prosecution are designed principally to protect individual from having to defend themselves against charges supported by facts that are remote in time. United States versus Rivera Ventura. This, and they give us some case numbers, okay, and then it says that certain is acute in this case where the government seeks to rely on the retroactive extension of criminal statute of limitation to prosecute a case based on conduct that is more than 2 decades old. Since the time of the alleged conduct, memories have faded or have been corrupted, documents have been lost or destroyed, and witnesses have died or the detriment witnesses have died to the detriment and prejudice of defense. Retroactive application of 2003 amendment would not only fly in the face of congressional intent, it would violate notions of fundamental fairness. Ah, yeah, this is some good stuff. Okay. B, count number 6. You guys understand what she's saying? She's basically saying, this is my layman's understanding of this, right? They're saying that she's basically saying that the time has lapsed. The statute of limitation has been reached. Even with the new law that they apply, we know they said that the person up to the age of 25, right? There was a time limit that they gave for them to do that. Any case that was prior to 2003, they had a time limit for them to get it in, and they didn't get it in, right? So now they're trying to use the Congress new law where they said there's no age limit for someone who's been uh, a victim of a crime if they were under the age of 18, because now there's no time age limitation. But they missed that window of opportunity for them to get those cases that was before 2003. You guys get it now? Get what I'm saying? Okay. That's my layman's understanding of it. But I will send this off to Patrick, and he can give us a little bit more detail, and we can talk about this with Patrick later on, okay? But I'm just giving you my layman's understanding of it, okay? All right, so now we're going to the B part where she's talking about 6 through 8, also time bar, since the limitation period for the counts was 5 years rather than extended period of set out by 3283, which is exactly what I said. Okay. They missed the opportunity for them to do this. They waited too late, and that's what she's basically arguing. That the time has already lapsed. Not only the time for that small window they had. I don't know if you guys remember in Arizona, they had changed the statute of limitation for age for someone who was abused at the age of 18, and they gave the people from old cases up to I think it was August, no, it was December 2019 to get it in, right? And that's when they were trying to get that rock star one. I forgot which one it was. They were trying to get him in Arizona, and they missed the deadline, so they couldn't come after him because the girls claimed that she sat on his lap and all this kind. I can't remember who the rock star was. Was it? It wasn't Mick Jagger. It was one of those guys. It was one of those rock and roll star. But they tried to get him, and they waited too late. They was trying to get it in by the deadline, which was the 31st of December. That was in Arizona. They missed that deadline. And so anything that happens after the new law is when, there's no time of limitation. But if it happened before, they had until this small window to try to get those people from the old cases. And they missed that window. So that's basically what she's saying on this one. They missed that window, so they cannot come back because the time bar is here. Okay? That's my short way of explaining it to you guys. But I can't. Once I remember who was the one in Arizona they were trying to get, because I remember they were trying to file charges on him and all this kind of stuff, and then they didn't get him. All right, because the small window of time had passed, and that's what she's basically saying. You can't come after him now because the time is gone on both laws. The law that they gave them a certain time limit, and the law that tells them that the age is not is no limitation of age. Now, if anybody do a crime now, that law applies. There's no limit in the age, and there's no 5 years or anything like that. Now, if they do it now after 2003, but everything that they showing supposedly happened before 2003. Remember? Okay. All right. Even if 2003 amendment is retroactive. See, that's what they were trying to say. The retroactive. They're trying to get stuff that happened prior. Okay, even if 2003 amendment is retroactively applied to the defendant's conduct, count 6 through 8 will still be time barred because 3 to 8 does not apply to those offenses. Section 3283 extend the statute of limitation only for offenses involving the sexual or physical abuse or kidnapping of a child under the age of 18. But count 6 through 8, which charges conspiracy to receive pornography, and the complete offense is not necessarily an offense that involves sexual abuse of a minor. The United States Supreme Court has acknowledged that an offense or crime that involves certain conduct means an offense that necessarily requires the conduct. Schiller versus United States. It states that offense that involve language requires us to look at the elements and the nature of the offense rather than the particular fact at issue. The Supreme Court has recently reiterated that in all but most unusual situation, a single use of statutory phrases must have a fixed meaning. United States versus Davis. Then they give us case law. Thus, only if the offense necessarily entail the identified conduct, can it be said to be an offense involving that conduct. And they gave a case again, and it says in interpreting offense that involves fraud or deceit to mean offense with elements that necessarily entail fraudulent or deceitful conduct. This approach dates back to Bridges versus United States, where the court construct the wartime suspension of limitation act extension to of statutes of limitation for any offense involving fraud or attempted fraud against the United States. Gave a case and an emphasis added. The Supreme Court held that the extension was limited strictly to offenses which defrauding or attempting to defraud the United States is an essential ingredient to the offense charge. Bridges, and then they give case number. Thus, the court held that the charges that the defense knowingly made and conspired to make false statement in a naturalization procedure, and that he aided and abetted a fraudulent certificate of naturalization, which subject to the general statute of limitation and not the exception, because fraud is not an essential ingredient in such offense, even if the conduct alleges could be constructed as fraudulent in the general sense of the word. See United States versus Morgan in case number, a venue statute that states any offense involving the use of the mail, transportation, or interstate or foreign commerce. The court held that the most natural reading of the statute is to construe any offense involving by reference of the element of the offense at issue. Under the necessarily entails approach, 3283 does not apply to count 6 through 8, since conspiracy to receive child pornography and the complete offense of receiving child pornography does not necessarily entail sexual abuse of a child. In United States versus Continentos, The court held that 3283 does not apply to charges of possession of child pornography. Looking to the element of the offense, the court concluded that although the production of the pornography did involve sexual abuse of a child, the offense of possession of the child pornography does not involve sexual abuse. Thus, was the subject of the general statute of limitation. The court wrote that a producer of child pornography will possess it at the time of the abuse is insufficient to charge our view that the offense of possessing child pornography itself does not involve the act of child. The sexual abuse of a child ID at 817 consists with the preceding authority and principle of law. Count 6 through 8 of the superseding indictment that charges defendant with conspiring to and receiving child pornography is a subject of the general 5-year statement of limitation. I guess it meant to say statute, but it says statement of limitation, because those offenses do not necessarily entail sexual abuse of a child. As such, the statute of limitation for those offenses expired no later than 2012, making those count time barred. Conclusion. For the foregoing reason, this court should dismiss the entire superseding indictment, which the expectation of the 5 count, which already the subject of statute of limitation challenge. Respectively, Jennifer Bonjean, attorney for Robert Kelly. All right, guys, that was it. That was it. That was the conclusion of that. Anybody have any questions? She's basically saying that, which we've been saying from the beginning, there was a time of limitation. I know I was talking to somebody in the group I was in. We talked about that. Tamiri, was it us? Was it? I don't remember where. But we talked about the statute of limitation on those cases. Yeah, it was Tamiri. Was it me and you? Tamiri, speak now, forever hold your peace. But as I was saying, that is basically it. Just keep watching God move, guys. What you need to be doing, as I placed in the beginning of this live, is we need to be praying. We need to be turning your plates down and going to God. Because one of the things I did learn, that God is such a gentleman that he will not interfere in human occurrences and human thing unless we ask him. And by asking him is when we pray, we ask him to intervene. There's a law. God does not violate his law. God would not violate. He gives us free will. That's why when we do things, he allows us to do it unless we ask him to intervene. And that's what we're asking him to intervene in Robert's situation, because God is not going to come in unless he is asked. Yeah, we did. Yeah, T-girl. See, thank you. I know my memory served me right. I know my memory. We were talking about that. And it seems like we're not even lawyers and we knew certain things. we were reviewing some stuff. Anybody have any questions? Thank you for taking the time to bring us this information. It's great. We appreciate it. You're welcome. But y'all, let me tell y'all something. I told y'all the next few days, I'm spending it with my Heavenly Father. And I have some ladies who I am in prayer with. We've been taking care of God's business. And you're going to see God move. You're going to see God move. Because we sincerely believe and know for a fact And it's no coincidence that her motion happened today while the fast started 12 o'clock today. It's no coincidence. It's no coincidence at all. We're going to sit back, the believers who's been turning your plate down, because I told you what goes hand in hand, prayer and fasting, and watch God move. Watch God move. I'm done. I'm not going to go on. I will continue to believe God. I already know everything's done because we asked God. We gave God permission to intervene. And people are like, oh, how can you tell God what to do? He's sovereign, but he follows his own law. He follows his own law. And he gave man free will. It is done. Amen, Joycelyn. You're absolutely right. It is done. And it's a faith walk, people. It's a faith walk. It's not that wishy-washy, hocus pocus thing. No, it's a faith walk. Where I believe once these 3 days of fasting and praying is over, miracles is going to happen. Doors going to be flung open. That's what I believe. And on that note, I got to go. Have a good one. Bye.